The question at hand is, in a nonpartisan way, how do we address the unquestionable nonpartisan crisis we're having in regard to the Constitution? The senator is an expert. So I will please let me introduce her fully. Sujata Gadkar-Wilcox is senator-elect as of 2024 for Senate District 22 in the Connecticut General Assembly, representing Bridgeport, Trumbull, and Monroe. She serves as the chair of the new Government Oversight Committee, the Regulations Review Committee, and a select committee on special education. She will also serve as vice chair of the Judiciary Committee and the Higher Education and Employment Committee. You got a lot of hats.
Yeah,
Sujata.
Yeah. First session, I was like a little overwhelmed.
Just in the legislature.
Yeah.
She's also professor of legal studies at Quinnipiac University, where she teaches classes in constitutional law, comparative law, and human rights law, among other subjects. She is the executive director of the Oxford Consortium for Human Rights and a Fulbright Nehru Scholar. Sujata was earlier appointed by Governor Ned Lamont to serve as a commissioner on the Commission on Human Rights and Opportunities in Connecticut. Her appointment was unanimously confirmed by the Connecticut General Assembly in both the House and the Senate. Sujata has worked with students to implement principles of community action planning in the local community and has organized human rights workshops at the United Nations and Oxford University. Sujata received her BA in government from Cornell University, her Master's of Philosophy in Politics from the New School, and her JD from the University of Pennsylvania Law School. Prior to coming to Quinnipiac, she served as the program director of Juvenile Law, a nonprofit legal education program helping students understand their rights and responsibilities under the law, and before that worked as a litigation associate. Sujata has presented papers, given podcasts, and published articles on domestic violence law in India, First Amendment jurisprudence in the United States, and legal pluralism in constitutional discourse. And her work in political engagement is discussed in her TEDx talk on a politics of the public good. Let's go home and look that one up. Sujata is interested in understanding how different voices and perspectives come to shape constitutional principles and conceptions of justice in both the United States and Indian constitutions, and is currently writing a book on Dr. B.R. Ambedkar and the drafting of the Indian Constitution. And I hear you are also headed for your PhD. Yes. Wow. I'm pleased to introduce Senator Sujata Gadkar-Wilcox.
Thank you. Thank you so much. I very much appreciate that. You know, I stand here, though, I always think of myself as a kid of immigrants and a member of the League of Women Voters and a member of the community, which is why I ran for the Senate in the first place, because I'm a teacher of democracy and a very much a community-oriented democracy, a grassroots democracy. And so to embody that kind of politics, which is, you know, what we have here. And so I'm so honored to be here, and thank you for coming out and taking the time to be here to talk about the Constitution. So I've only been in the Senate, you know, for a few months, and I've said this many times, it feels like a few years already because so many things are happening. But I've been teaching this document, I keep a copy of the Pocket Constitution, for more than a decade. And that's why I say these are not partisan conversations. I'm here primarily as a professor of constitutional law. And we have debates, by the way, in the classroom. We have robust debates about how we interpret the Constitution, and sometimes interpreting the Constitution from a different perspective, whether you're going to interpret it strictly or broadly, actually will create different outcomes. But the debates that we're having today are not necessarily connected to those kinds of debates where we can actually kind of debate, you know, how do we want to interpret the Constitution from a particular lens. And that's really the problem, because We're seeing things, and again, it's not about one administration. We have seen things over time where, in fact, maybe we've been willing to compromise on some constitutional principles that we should be thinking about. So I think this is the time for us as a community to think about what this document means and to have a discussion about it in public, in person, where we can understand its value and why the framers designed the document the way they did. Is it perfect? No, but I'm a huge admirer of this document. I love this document because it attempted to balance power in a way that was supposed to prevent corruption. And of course, there has been talk about tinkering with it over time to make that balance, more perfect. And we'll see the more perfect union. But the most important thing is if there's a framework in place that creates a balance of power because it's a response to governmental overreach. I always think of the Constitution as a response to the Declaration of Independence. So if I don't know if there's a reading here about the Declaration of Independence. We do one every year in Trumbull. And that's my birthday, by the way. I was born on the 4th of July. So we have a reading every year on my birthday in Trumbull and in towns and throughout the country, actually, the reading of the Declaration. Why? Because the Declaration is a list of grievances as a reminder to say, here's what happens, right, when you allow too much power to be concentrated in one hand without limits. And so what the Constitution is, you'll see, is an answer to a lot of the grievances that are there. Quartering soldiers, it's in there. No due process. The framers, right, were also censorship of speech, being charged with crimes without notice of offenses against them. These are all things that are listed in the Declaration of Independence. And again, that was a violation of the social contract, the contract that our government has to provide our most fundamental rights. And the Constitution is there to protect those. So that's just, that's an initial framework for us to say, that's why this document, to me anyway, is so important. And also, it's the people's document. And we're not here, in other words, we're here because people, I think, are mostly worried about what's happening with the Constitution. So that's not a great reason that we have to come together and talk about the Constitution. However, the silver lining for me is I'm so glad that people want to come out and talk about the Constitution. People are downloading the Federalist Papers. They want to know, well, what was the history here? What would they think about with each provision? How amazing is that? I think that's amazing because this document always belonged to the people. And too often now people feel like it's up to the courts. I'll give it to law students. I'll give it to lawyers. I'll give it to politicians. No, this is the people's document. And also the way forward today is this. It's not leaving it to the lawyers. It's not leaving it to politicians. That's why I'm here in a community outside of my Senate district, because this is about people mobilizing to say, we swore an oath to one document, right? Especially all elected officials, not to our parties. We swore an oath to the Constitution. Everybody. That's the one thing we have in common. We all swore an oath to this. So let's take this seriously and talk about it. So let's start. What I like to do is start by looking at, everyone should have at least a pocket constitution, and there are some constitutions. I have some printouts here if you need larger font, as I do these days, to be able to read it more carefully. So I just wanted to start out by talking about I want to make sure we all are on the same page in terms of the background and the context. But I've been doing these talks throughout the state, and they've been wonderful, and they've all gone in different directions because people have questions that relate to different aspects of it. So if you want to interrupt at some point with a question, that's perfectly fine too, and we can sort of take the conversation in whatever direction people are interested in going. I'll start by just providing some background information so we can all be on the same page. And then as questions kind of come up with contemporary issues, happy to take those even along the way, or we can do it a little bit later. So the first thing I want to make sure, you might have heard these debates on social media, are we a republic or are we democracy? We're both. We're a constitutional democratic republic. And that's little d, right, democratic, and little r, Republican. We have a Republican form of government because we have institutions like courts that are there to make sure they check unlimited power by a majority. When we have pure democracy, everything is just rule of the majority. But if 90% of the population wanted to just eliminate the freedom of speech for the other 10% of the population, that's not going to be okay just because 90% of the people wanted to do it. And that's where we have institutions. That's what makes it a republic, because we have institutions like the courts, representatives, right, that are actually speaking up to think about kind of how we balance power and those checks and balances. But we're a democracy because, as we'll see, the most important words of the preamble, the first three words of the Constitution, we the people, that is the source of authority for the Constitution. That is the source of authority for our entire legal system, popular sovereignty. And so that's the democratic influence, that there has to be some way that people can deliberate or have access to understanding what the laws are, that they have to know what the laws are that are being passed. Even if they're not in the chamber themselves deliberating every single law, we have a representative government, fine, but there still has to be based on the consent of the people. That is a philosophical foundation. And to me, we're also not thinking about the ways that, again, more recently, and not just in this year, we've seen a number of things that have maybe led us to more of a constitutional crisis, but we have seen a decline even when we see things like gerrymandering and the courts not stepping in to correct gerrymandering, campaign finance reform, unlimited amounts of money now going into public campaigns. That to me is a violation of the very fundamental theoretical foundation of we the people. That's not consent by the people. That is now consent based on the special interest of the corporations that are able to influence those legislators, right? And unless we put a cap on that, we're violating now popular sovereignty. So we have been getting here. Everyone's like, what happened to our democracy? It was really but our democracy was already in danger. That's how we got here, right? It's been sliding in decline, and this is why I say I'm so glad that people are here talking about the Constitution, because we have to be more vigilant about making sure we're protecting that the way that the power has been balanced to prevent us from getting there. So that's our constitutional democratic republic. And then another important part of this conversation is to think about the role of these three different entities. So we have the people, that's sort of the source of authority for the Constitution. So we can think of the people separately because there has to be some way, whether directly or indirectly, they have some say in government. But we also have two very important, separate, autonomous, equal, parallel entities, and that's the federal government and the state governments. And I always tell my students, the federal government is not over the state governments, not at all. They're parallel. They have different, and we're going to look at the roles of the federal government and the state government. And when they come into conflict, and what we're seeing today is there's some tension between the federal government, for example, ICE, which is a federal agency, right? And they do have the power over immigration, because that we're going to look at Article 1. It's in the Constitution. The federal government has power over immigration. However, when you're walking around the state of Connecticut, for example, and you're entering a state courthouse, a state church, a private residence, we have rules of due process in the state of Connecticut that have to be followed. And now you're running into a clash of two sovereign jurisdictions, right? And who gets to say? It's actually the state, because the reserve powers are in the 10th Amendment to the states. And we're going to look at all of this. But those are some of the examples of the state governments and the federal government having their own lane, and sometimes those lanes overlap, and then thinking about where's the conflict. So one important question is, how many constitutions do we have? One federal constitution. Yes. Every state has a constitution as well. This document is our federal constitution. The US Constitution is the federal constitution. Most states actually provide more rights than the federal constitution. And they're allowed to do that because, again, separate autonomous jurisdiction, they can't provide less than the US Constitution. So you cannot undermine the rights in the federal constitution. You have to at least provide those, but you can provide more. So Connecticut, for example, has more categories when it comes to the Equal Protection Clause for discrimination, anti-discrimination policies than under the federal laws, because as states, we can do that. So what's really important is this sort of separation between state and federal government, and then we'll look at kind of the balance of power in Article 1 and then the 10th Amendment. Okay, but I wanted to start because when I say I'm so glad that people have the document, you can actually go through an entire class in law school in constitutional law, believe it or not, and never look at the Constitution. Because we look, which people are shocked by, but it's because we live in a common law system, which means a lot of what happens when it comes to interpreting the First Amendment, right? There's a single line in the Constitution that says Congress shall not create laws that are abridging freedom of expression. That's only one line, right? One line saying Congress shall not act. But there are, in fact, limits on speech. So how do we know what they are? We're not going to know them from this document. We know them because we have to look at all the court opinions to show us what those limits are. And that's why people can, say, okay, I know a lot about this document without ever looking at it, because so much gets filled in over time by the courts. But I think there's so much in this document that is so valuable that we should start by looking at the document carefully. And so one thing I like to do is just read the preamble together. Every word in this document is so rich. It was intentionally selected and it all means something. And so let's start here so that we can actually read the document itself together and start with the preamble. Does anybody want to read the preamble? Or if we have microphones here. Let's do it together. Okay. All right. Is everyone? Right. Oh, I like this humor. Okay, great. So, we the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Those are, every time I read it, I moved, honestly, because they're powerful words. So starting with we the people. That we already talked about, right? We the people. That means there has to be some way that people have a say in government. And we really need to start thinking carefully about things like gerrymandering and campaign finance reform, because that is violating a philosophical foundation of the Constitution. And I would argue there's also a guarantee clause that the federal government is supposed to guarantee Republican, again, little r, Republican form of government, which is supposed to balance power. But when we're allowing all of this money to be flowing into campaigns, no term limits, no lobbying limits, it's not starting to look like we're holding up that foundational philosophy. I would argue that it's already a violation. Is there already a question?
Is there a place in the Constitution where it says who upholds that? Who's responsible for upholding that? The people?
Yes, that's what's interesting about the preamble. The preamble isn't technically part of the structure of the Constitution, but yes, the Constitution does answer that in Articles 1, 2, and 3, which is the balance of powers between the governments, and then the balance between the federal and state governments. That's how it's supposed to automatically maintain itself because of the structure. Because the structure is made to balance power. But yeah, exactly. When it doesn't do that, that's what we need to think about, right? That's exactly why we're here. And so in here, to form, so this is a very famous phrase, to form a more perfect union. That phrase is in reference to the balance of federal versus state power, right? Because before the Constitution, we had another famous document, the Articles of Confederation, which really didn't work because it gave too much autonomy to the states. In other words, states were coining their own money. They were able to sort of handle their own postal service. You can imagine what happens if you're trying to go through the country. It doesn't really feel like a federation of states. It's not a United States unless you have some centralized power. And if anyone remembers the EU before there was the euro, right before the European Union came together, that was an economic agreement to create a more ease of travel and also, sort of economic agreements across states, because you don't lose money in the transaction cost when you keep converting money. So before there was the euro, every time you had to go to another country, you kept exchanging money, right? It's inconvenient and it costs a lot, by the way, when you have to do it. And so that same thing was happening. It doesn't work to create a sense of unity. So that didn't work. So the Constitution created a balance where they added centralized powers, and we're going to look at that. That's Article 1, Section 8. But they're very limited. So we're like, how do we get a government this size? Article 1, Section 8 is it, period. If it's not in Article 1, Section 8, that power does not exist with the federal government. Everything else is left to the states. Zoning, housing, contracts, property, everything else is left to the states. And so that's the reserve powers clause, and we'll look at that too. But this is the more perfect union balance. It's like how much central power, and in truth, that was probably the thing, the ideology that divided the parties was how much power to go to the central government. Both parties are somewhere in the middle now. So the party platforms aren't what they were initially. And they also switch on that because, right, it's interesting depending on whether you're supporting a federal executive, you might support more federal power. And when you're not, you might support more state power. So you'll see the parties going back and forth, which is why the framers themselves were wary of parties, right? Because they weren't sure. I'm not even sure that 2 parties is the right number because it's only marginally better than 1. That's what some scholars have said, right? It's marginally better than having 1 party. What is the right number? I don't know. The framers didn't know. Maybe 10 is too many, but 2 seems to be too few because you start picking up all these interests and people don't feel like their voice is represented. Plus, we have a first past the post majority. So we have a system where people don't feel their voice is heard because if they're not with the major parties, they don't get represented at all. So that's something, right? But again, the loyalty has to be to this document, not necessarily there. So that's the more perfect union. That was sort of the division between the parties to establish justice, right? What's important is that we have things like especially due process. It's something that ensures that when people are accused of a crime, there's some process in place, right, to make sure that that is accurate. That they're not being targeted, which the framers were often being targeted, right, by the state. And so this document, there's a healthy skepticism of the state built into the document. That is not un-American. That, in fact, makes you a patriot. And I think that narrative is being twisted a little bit, that if you ever question what the government says, or you ever question what the executive says, somehow you're not American. The whole document questions the reach of the government because we want to make sure it's not too much, right? So if you're engaging in peaceful protest, not violent, but nonviolent protest, that's in the First Amendment for a reason, because you're actually, that is being a patriot, to say something's not working, I want it to be changed. So that's establishing justice, ensuring domestic tranquility, right? Creating, again, a unified whole, providing for the common defense. So there's an internally facing role for the United States and then externally facing. And that largely is federal, right? Because the country can be represented federally, promote the general, and here's what's important. It's always been both. Promote the general welfare and, in fact, that's before, secure the blessings of liberty. So what's interesting is recently, all we ever talk about are having liberties. And of course, having liberty interests and defending them is important, making sure our rights are protected. That's always balanced against the general welfare, always, in every amendment. So if your speech, for example, is threatening, that speech can be regulated there's an exception. That speech can be regulated. Why? Because because overall it's harmful to the general welfare and to the public. So there's always this balance. And this issue came up, remember, during the time when, can the government require people to wear masks, for example? Well, it depends, because wearing a mask is a deprivation of a liberty interest. The question is, but that doesn't mean they can't do it ever, because it's just a deprivation of your liberty. It depends on, especially at that time, what did the science say, right? Well, was this the only way to prevent the spread of a pandemic that would never have ended, right? As the science changed and as the vaccines came out, the answer actually changed. So initially, maybe yes, because that justification of a slight deprivation of liberty was justified to prevent this huge pandemic. As things sort of got under control, now probably the answer is no. You can't require the masks because that seems like you'd have to have more of a justification for a deprivation of liberty. But you see that that's always been there. And right, it's never been like, this is my absolute right to do whatever I want. There's never been an absolute liberty right. It's always been something that's been balanced. Okay, great. So you see how much is in that preamble. That's why I start with that. All right, and then my favorite clause, which I think is what I think, makes this document stand out beyond all world documents, is the abolition of titles. This is my favorite clause in the Constitution. Hardly anybody ever talks about it. We're talking about it a little bit now because we talk about the emoluments clause of whether or not you can profit from being in office. You can't. And the framers were very, very clear about that. You cannot profit from being in office because you serve the office for a limited time and then you leave. How amazing is that? So if you're a farmer, you're a farmer. If you're a teacher, you're a teacher. If you're a librarian, you're a librarian. You step back into your role. So you serve the office for a limited amount of time and then you leave. And by the way, that's not true everywhere. So in the UK, for example, we still have titles of nobility. And despite what people say, it's not just symbolic. What that means is there's actual economic interests that come with that get to be held within the family, that get passed along with that title. That's property that's away from the rest of the public, right? So there's actual power in those titles. The framers, they could have given themselves titles, right? They were creating the government. The fact that they said, no, this is a government of the people, I think that is the most important provision of the Constitution. And it says a lot about them, that this document has always been about checking power, not sort of empowering yourself to do things that are sort of beyond limits or beyond constraints. And so that's why this is so important. No titles of nobility. And except for the president that gets to keep the honorary title once you leave office, and it's only symbolic. Nobody else really even gets to keep their title. You're always former whatever you are. So you serve your office and you're former whatever. Only the president can keep the actual honorific president. They can always be called president no matter what. But again, just an honorific. So I think that's amazing. And here's what's really, if we look back at the Federalist Papers, which everyone is reading now, which I'm so happy about, we see that, there was a warning, right? That if people were angels, we wouldn't need a government. But the first thing we have to do is to get the government to control the governed, and the next is to control itself. So we have to create rules so that people are abiding by the laws, and there's some laws that fairly apply across the board to everyone. And secondly is getting the government to control itself. So that's the most important thing. The other balance of power that's really important, and we've had some questions recently that have come up, is separation of powers. So federalism is a division of powers between the federal and the state government, and we're going to look at that. But there's also been some question of whether or not one branch of government, for example, can do things that are actually otherwise assigned to the other branch of government. So, for example, initially a few months ago, we saw all of those funding freezes, right, that were coming from the directive of the executive. Now, the problem with that is those agencies, right, that initially allocated the funding, they are executive agencies, meaning Congress created those agencies and gave the power over to the executive to kind of implement those laws. But those statutes in creating those agencies come from Congress. And the money that's allocated from those agencies comes from Congress. And unless Congress puts those restrictions on that funding, it's really not up to the executive to do that. Now, the executive can put some restrictions on the funding as they're implementing, but the problem that was happening is, one, they were starting to rescind funding that Congress has already allocated. That's unconstitutional. And two, they were starting to put conditions on funding that had nothing to do with the statute. That's unconstitutional, because it's not that they can't put some conditions related to the actual theme of the statute. They were starting to put conditions that had nothing to do with the statute just based on political preferences. That's unconstitutional. And that becomes a separation of powers problem, because that is not the jurisdiction of the executive. That power is derived from Congress. Those statutes come from Congress. Those agency powers come from Congress. And so when you go back and Congress does it, that's different. Then we can disagree on a policy level whether or not we want Congress to do it. But when an executive steps in and says, I'm going to do this in lieu of Congress, that's a problem, right? And this is where I hope we can get to a better point too. What's really frustrating me nowadays is everything is called partisan, everything, and that's really a problem, because we should be separating out partisan debates from constitutional debates. And again, not that there aren't debates on the Constitution as well, but they don't align with policy issues. And that's what's happening today, and that's a real problem. So for example, let's take immigration. Okay, when it comes to the power, and I'll actually go to the next slide for that. So when it comes to immigration, so Article 1, Section 8, and I'm going to ask everyone to turn to Article 1, Section 8, if you can find it in your either your pocket constitution or the document that you have. It's on the back of the second page of the handout, the printout. If you look at Article 1, Section 8, that outlines the powers of the federal government, the powers of the federal government. And so everything listed there, including immigration, so I want to talk about that, is up to the federal government. And so when it comes to the partisan issue, okay, if you want to say, look, how many people should be deported? Should we have a pathway to citizenship? Those are questions that are policy questions that have to be debated in the policy realm. However, when it comes to things like due process proceedings, whether or not you can deport somebody before their due process proceeding is completed, that is not a debate, because you cannot. Because we have rights of due process in the Constitution. We also have other agreements that I'll come to when it comes to due process and immigration that we've taken on that aren't partisan. We've taken them on, as a country when we signed on to the Refugee Convention, and we agreed, and then we made it a domestic act, the Refugee Act, that we will not send somebody back who's claimed a fear of persecution from a country of origin. We will not send them until they have had a due process hearing and we can substantiate whether or not that's true. So that's the basic entitlement, is a due process entitlement. Now I can tell you, and I was a litigator, and I've done an asylum trial. That's like the minimum standard, the minimal standard you could possibly have, because it's not the same process as you get in a civil court. But if we're even violating that, that's a problem. Because that is the one commitment we made, right? And again, that's why I say we should separate it out from talking about how do we reform lawful immigration, what are other immigration reform policies. That is a policy debate. But there is no debate about violating due process. That is just unconstitutional. And this is where we have to stop calling things debatable that are unconstitutional. They're just not. And that's where I think we have to draw the line. So I just want to go back to how do we establish this, Article 1. So if you look at Article 1, Section 8, take a look. What powers do you see there? Yeah, there's some more constitutions here in the box. There are. There are more in there. Yeah, feel free to. And what powers do you see? These are all the powers of the federal government. Anybody want to shout out?
Borrow money.
Taxes.
Borrow the money.
Borrow money, coin money. Great. Okay, good. So a lot of the money gets collected, right? It gets collected at the federal level. Commerce. Now that's the big clause. The Commerce Clause is the one clause that has led to the expansion of the federal government over time. I spent 2 classes on it in constitutional law, so I won't talk about that, but it's just for you to note, these powers are pretty specific. They're very, very limited, except for the Commerce Clause. And there's another elastic clause, but it's mostly the Commerce Clause that has been expanded over time. The other powers are very limited, right? And they're very specific. So we see, what else do we see? Things like post offices and post roads. So that's why tampering with the mail is a federal offense. When you tamper with it, why? Because it's in Article 1, Section 8, and that's a power of the federal government. Naturalization is also a power of the federal government. So it is up to the federal government to decide policy around naturalization, right? Remember that the conflict is when the federal agents are violating state protocols. Because when you're walking around the state and violating state protocols, that's a violation of the 10th Amendment, which reserves the powers for the state to decide what happens within the state boundaries. So we have that. We have to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Anyone know what that is? Patents, copyrights. So it doesn't make sense to do a state by state, right? So this is why we have centralized. Same thing with bankruptcies. And then, of course, a lot of the external facing defense, right, for when it comes to maintaining a navy, and when it comes to like the troops, we have the power, obviously, on the federal level, because we're not going to have each state responsible for that. So again, we see in Article 1 this very specifically identified powers of the federal government. And then what's important, and you don't have this in the copy you have, but for those of you who have the pocket constitution, if you look at the 10th Amendment, right? Yes, of course.
What does it mean to constitute tribunals inferior to the Supreme Court?
Yeah, great. So all federal courts fall under the, yes. So to constitute not only a Supreme Court, but federal court, appellate courts, and then we call them district courts, which are trial courts underneath that. So that's a federal power. And then states have the power to create state courts. And those are also separate jurisdictions, by the way. State courts are separate from the federal courts, and they don't always overlap. They're not able to hear the same issues necessarily. Yeah. Yeah, the only time you have the big back and forth is when it comes to the Bill of Rights. So when the Supreme Court is a federal court. So generally speaking, it doesn't listen. You don't hear Supreme Court decisions about contract breaches and property rights and state criminal laws, because they don't have the jurisdiction to hear that, because they're a federal court. Now, what they do have the jurisdiction to hear is the first 10 amendments to the Constitution, which are the Bill of Rights. And those amendments through the 14th Amendment, so those 10 amendments and the 14th Amendment collectively we think of as sort of all of our civil liberties and civil rights, those apply to the states as well. And because they apply to the states, whenever the Supreme Court interprets the First Amendment, it applies to every state. Otherwise, Supreme Court interpretations on federal law are only limited to federal jurisdiction. It's not, they have no say over state law. No say over state law. It's the Connecticut Supreme Court that has the final say over state law. So if you have a contract dispute, you're not gonna look at a Supreme Court decision. You're gonna look at a Connecticut Supreme Court decision to figure out like what the legal rule is. So that's really, and that's again coming back to the separate jurisdictions and equal jurisdictions, right? Not one over the other. And what we're seeing today, which we see a lot of tension, is a federal government and particularly the federal executive saying, oh, well, I'm going to send in troops without the permission of the governor, the National Guard. No, you can't send in the National Guard without the permission of the governor. That's up to the governor. The 10th Amendment is the reserve powers. So this is where, again, it's like, this is not about partisan issues. This is about a constitutional limit. When the governor says yes, you can say yes. Now, there are times when actually you can send in the National Guard outside of, when the governor doesn't consent, but that's usually because there's a constitutional violation, like an equal protection violation. But when there's no so there are certain parameters that the court, by the way, has established where you can send troops in without the governor's consent. But if you don't have any of those conditions, you can't do it. And so we're getting this kind of back and forth where, we're really pushing the line where we never pushed it before, and that's the problem. Yeah.
Is it one of those loopholes if the executive declares an emergency?
Yeah, but that's the executive. Yes, if the executive, no, but there are certain conditions for that. I mean, if the state executive, like if the governor declares an emergency, that's, if they want it, you're right. Well, this is where all these lines are being tested. And also, it wasn't meant to just target certain states, and I got asked this question about like our immigration policy in the state, because we have the Trust Act, where we, do turn over information, right, to the federal government when it comes to crimes that we have identified. So some very violent crimes, and we added crimes of a sexual nature, for example, so sexual offenses, that information will go. But what's happening with the federal investigation is that they're targeting people who are coming to lawful court proceedings and then picking people up in the lawful court proceedings. And as a state, we have no obligation to help you in that federal investigation. So, and one of the questions I got was, well, aren't we putting a target on our back by not working with ICE? But we are working with ICE. We're just not working with ICE when it comes to, policies that, one, we disagree with, which, by the way, seem unconstitutional because you're interrupting due process proceedings. Two, it also seems fundamentally unfair. You're calling people back for a lawful proceeding, and they're showing up for their lawful proceeding, and then you're picking them up before that proceeding is completed. And in some cases, what has been happening is that the executive, right, this administration has revoked lawful status. So you've revoked humanitarian parole, you've revoked temporary protective status, and then you're deporting people and saying you're undocumented. That seems fundamentally unfair too, because it was like, wait a minute, you revoke the status and now you're deporting people by saying that they're undocumented. So again, it's not just the constitutional issues. It's just like some of this just seems, it's just morally questionable. That doesn't seem right, that you're sort of changing the rules and then holding people accountable for those kind of rules. And then as a state, we don't agree with that because, again, there are constitutional lines, and it's not the state's obligation to help the federal investigation. Now, we can't interfere, and we don't. State officers are not allowed to interfere with the ICE investigations, and they don't. But again, there's no obligation to help. And what's been happening is, in fact, going the other way. What we've had in Stanford, in Danbury, we've had ICE officers ignoring judicial marshals. That is unprecedented. Just ignoring judicial marshals, coming in masks, not identifying themselves. I mean, can you imagine what would happen if somebody just did that as a copycat? Like you're masked and you're not willing to identify yourself, and you're armed, and you don't have to register with a state marshal. So it's those issues we're kind of tackling now, because and this is, again, but that's a it's not just, it's the Democrats and Republicans. No, that's a constitutional issue. What's the state's power here? What's the federal government's power here? Where do we draw the line, right? That's why we have to have these conversations. Was there another question? Yeah.
Quick question. The section that talks about the militia, can you explain what the militia is they're referring to?
Oh, yeah. So a militia was always kind of a collective, general purpose militia, right, to serve a public interest, as opposed to, for example, and this is also, an interpretation of the Second Amendment, which also refers to the militia, as opposed to formal professional troops, which are the Army. So a militia can be sent in. So the professional army is not supposed to be marching within the boundaries of the United States. Right. That is an externally facing defensive protocol, right? That you have armed forces. But what was happening, especially at the time, is you had a lot of mercenaries that were being hired as professional soldiers. And so in order to protect, that's why states were allowed to have militias. Because in order to protect the state from the professional army, militias, but militias, again, were not sort of these narrow special interest groups, right? Militias were supposed to be broader, serving the public good. There were groups that were serving a larger public interest. I mean, what's interesting is actually, if you think of sort of the Sons of Liberty at that time and the Sons of Liberty today, they're actually very different organizations. And at that time, you could probably make an argument that they were much more focused on a broader sense of public concern, whereas now it's like a much more limited focus. So I think it also depends on how, militia has been interpreted, and that goes back and forth, particularly in connection with the Second Amendment.
My question really is, do we have something that's designated as a militia today?
Well, I mean, the National Guard is.
Oh, that's the equivalent. Okay, thank you.
Yeah, so that's why the National Guard can come domestically, but there can be public service militias, and this has always been the question on the Second Amendment: was the right to bear arms supposed to be a collective right for the militia versus an individual right that you can just bear whatever arm you want? So there is definitely a right to bear arms, but what is the scope and context of that right has been the debate. Yeah. Yeah. Great. Okay. So I just want you to look too then here for the 10th Amendment, because the 10th Amendment it says the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. That's interesting too, because the federal document always interchanges the states and the people. because at the state level, right, people are more accessible to you. So that's more of a democratic process because you're more likely to be engaged at that level. But what's important about that is the reserve powers are with the state, not with the federal government. So if there's ever a question about jurisdiction, right, it's actually the states that have more jurisdiction than the federal government because they have the reserve powers. Okay. And then I just wanted to say one thing about due process. And here's where it's important that the court has held the line on due process, even though there are some things like campaign finance reform and gerrymandering that they haven't really stepped in on. Due process is one of the most fundamental rights, if not the most fundamental right in the Constitution. It's in fact the only right that's in the original 7 articles. So the Bill of Rights are the first 10 amendments to the Constitution. Remember, they weren't part of the original Constitution because there was a debate as to their nature and purpose. But what was in the original 7 articles is the writ of habeas corpus. And the writ of habeas corpus is a due process right. If you're ever charged or you feel you're wrongfully detained, right, you should be able to be heard. And that's in the original Constitution. Then we have the 5th Amendment, the 14th Amendment. We have, again, protocols around due process. And when it comes to, because this question is coming up, particularly currently, right, whether or not you're allowed to deport somebody that's in the middle that has claimed a fear of persecution. And we have 2 acts that we've signed on to, not to mention, these are our domestic acts, plus the Refugee Convention, which is a global treaty that we signed on to and then made a domestic act to say that we're not going to deport somebody who has a credible fear of persecution. So that means in order to determine that they have a credible fear, they're entitled to a hearing. And what's happening now is before that's even being assessed, people are being turned back. And in some cases, returned to places where they are likely to face persecution. And in some cases, returned to conflict zones where they have no connection, they don't speak the language, they don't share the religion, they don't look like anybody there. And in the case, like for example, there were a couple of individuals who were from Vietnam, and Vietnam said, we'll take them back, and they were sent to South Sudan. So you're talking, and that's sort of going beyond any kind of constitutional process because it's not the case that has never happened before. It's just that only happened in cases where the country of origin said, we're not taking this person, and there was some kind of violent crime or was like, well, we're definitely deporting this person. So what do we do? But like to just send people to whatever country you've selected outside of their country of origin is another kind of big constitutional question. Yeah. No, well, they're there, yeah.
So
And they've gotten, and based on the assurances from the government that nothing is going to happen to them. But again, this document, we don't rely on assurances from the government, otherwise we wouldn't have a constitution, right? We put protocols in place that make sure that people are not facing a fear of persecution. There's nothing that guarantees it except the assurance of the government in a conflict zone that they're not facing persecution. So that's for the problem. Yeah.
One of the most important things to remember about due process
Yes.
is it does not say citizen, it says person.
Yes. So great. Yes. So if you look at the 14th Amendment, and I have the, thank you. If you look at the 14th Amendment and the text there, it says, nor shall any state deprive any person, it doesn't say any citizen. You're absolutely right. Thank you for that comment. And that was intentional, right? So and this is why I say the 14th Amendment talks about states also not being able to violate these federal principles. It comes through the 14th Amendment. And that's for both equal protection of the laws and due process. And that's, by the way, the same thing with birthright citizenship. If you look at the text of the 14th Amendment, right? If you look right in the beginning, it says all persons born or naturalized in the United States are citizens, period. It's not debatable. We don't open up that debate. So this is where if we want to talk about different pathways to citizenship and what should they be, that may be policy debate. But when we say birthright citizenship, that's unless you want to amend the Constitution, it's in the text of the Constitution, right? So we have to stop saying things are up for debate or they're partisan when they're in the Constitution. And it can't be any more plain than that. Right. So exactly, I know, but but we know that that provision has only been created for so for example, if somebody's here at the United Nations, right, you're not technically in the United States because the United Nations has its own sovereign jurisdiction. Plus, if you're in some of the sovereign tribal lands, you have sovereign. So that's clause, again, we know this from congressional intent. That clause was specifically created for those exceptions. And again, it's unprecedented in the sense that the court has never questioned that. So we can't just start opening up questions that haven't been questioned before because it's sort of convenient, right? This is the problem. And then call them partisan and say, oh, we're just not opening them up because they're partisan. It's like we have a history of why when you're born at the UN, right, you're not really born in the United States. And when you're born on sovereign land, that's slightly different than being born in a state when it comes to tribal land. And so those are the exceptions. But you're absolutely right. It's that clause that was being debated. Yeah.
Diplomats too.
Exactly. That's why it was created, for diplomats, because sometimes you're here on for work, right? And you actually you have citizenship of another state. You don't want to transfer that over. You want your child to be born over there, and so the clause was created to create an exception for diplomats and then also for sovereign lands. Yeah, I give the example of the UN because mostly people are coming there for a political, it's the United Nations, so they're coming as in some kind of, ambassadorial context. So that's why yeah. Great. So one thing though, what's interesting, and again, the only mandate in the act that we have is this principle called non-refoulement or non-refoulement, which means we agreed, legal mandate, we don't send someone back, which means you have to at least provide that due process hearing. And then someone asked me in one of these other conversations, well, won't everybody just claim that? Probably, yeah, probably people claim that don't have a fear of persecution. But what they're entitled to is a hearing to determine whether or not there's a credible fear. You cannot deport somebody before the hearing because you just don't know, right? It's like you can't convict somebody before there's a trial just because they're accused of a crime because you have no idea whether or not there's enough evidence to substantiate that. So that's what's happening right now, which is the problem. And then at a policy level, we can argue that's not even good enough. We should probably have more. That's a policy debate, right? We say, look, that's like the minimal. That's the bottom, the minimum you can provide. Can we do something more? Yeah.
Who are you talking about? Who should be having this policy?
Yeah, well, so policy debate as opposed to a constitutional debate. Like when there's a constitutional violation, this is where I say let's not call that partisan. Policy debates we can call partisan because policy debate, if as the Democratic Party, here's our position on immigration, a Republican Party, here's our position on immigration. Okay, let's debate that. But here's our position on due process is not a debate because that's a constitutional mandate, and that's why I want to separate out. And also I want to separate out issues, where both administrations have done things that are problematic. So for example, and I always say this, and I said it at the time, under the Obama administration, there was a policy on drones where there was, where the White House justified the killing of U.S. citizens abroad in conflict. And the administrations have continued that since. So it's not just but that's a violation of due process, and it has to be called out, right? And that's a Democratic administration. And same thing here with the Republican administration. If you're deporting people before their due process hearing has been completed, that's a violation of due process, and we have to be able to call that out. So it can't be that the party comes before the constitutional mandate. Everything else that's like, well, what should our position on immigration be? Okay, let the parties convince the public about that, and you call that partisan, that's fine. But like, this is not partisan. And then the one, with the executive, what's important is there is this take care clause, right? That means that targeting political opponents for their speech, targeting states because you think they're largely from the political opposition or for whatever reason, that's not allowed. That's also it's not just it's not allowed and this is again a partisan debate of whether we like this or not. That's not allowed because it's unconstitutional, right? The laws have to be applied by the executive objectively and equally to all states in all contexts, right? That's a mandate. That's a mandate. So that so when states are being targeted or when people are being targeted for their speech, that's a constitutional violation. And we're just seeing sort of more and more things like that are becoming problematic. So just recently, I heard that, that we saw that there's an executive order that is criminalizing flag burning. Now, people may say, "Oh, well, I don't like the flag being burned, by the way, at all myself." But it's constitutionally protected for a reason, and that's what the court said. And in fact, it was Justice Scalia, the most conservative justice who voted in support of this constitutional protection, who said, if it were up to me, I would put everybody in prison that burned a flag. But I'm not a king. That's what he said in an interview. But I'm not a king, and we have a constitution, and the right in the constitution to protect people's ability to express themselves by burning the flag is more important than how upset I am that they burned the flag. And that's exactly right? Because and I think what's happening today too, and we should talk about this, is there's nothing in this document that talks about being a patriot as being American, right? Or patriotism as an end in itself. I think that this document is what makes you a patriot, if you believe in the principles of these documents and you uphold them. But what's happening now is the flag is a symbol of the nation, and if you burn it, that's a problem. But patriotism is not protected in the Constitution. It's not like a value. It's something that people should sort of take on because they cherish the principles in this document. That's what makes them patriots, right? That's what makes everyone here a patriot. You're here to hear about the Constitution. And that's the thing with the flag burning, right? Which I'm sure there'll be a big public debate about it, because it's not a great act. People don't like it. I don't like it either. But I think it's more important to protect the right of people to express themselves, right? Because what happened in Texas versus Johnson, one of our most famous constitutional cases, is it was a political act, in fact, right? It was an act to express that you were upset with the government. And we protect that in the Constitution. That's not un-American. That's protected in the Constitution. As a society, we can say, well, maybe there are better ways to express yourself, but not to criminalize it, right? That's been protected. And then there are also these recent attacks and restrictions on freedom of the press, and we saw, I guess I have here, the Jimmy Kimmel. Now, what was really interesting about the Jimmy Kimmel, again, I'm actually not a fan of Jimmy. I don't really watch Jimmy Kimmel all that much, but I do object to the Federal Communications Commission coming in and saying, I don't like what you said, you have to get off the air. That is a huge constitutional problem. And what was interesting to me is the pressure that was put on after that sort of brought that show back, although not in Connecticut everywhere because it was preempted, right? So that's another thing we have to talk about is media, but that's different. That's different than the state acting. But it was preempted in some of the districts in Connecticut because of the media companies that said we're not going to show it anyway. But when we have federal agencies or the federal executive targeting political opponents or targeting people for their speech, that's really a problem, right? Because now we're looking at that's the most fundamental right. And was there a question here?
Yeah, I just had a quick question on the whole Kimmel thing. How is that not extortion?
Oh, you mean for the FCC?
Yeah, saying that we won't give you your license if you don't take them off the air.
Well, it's a penalty, so they're not extorting, meaning they're not getting anything in return. So it won't meet the definition, but it's penalizing, which is the violation of the amendment of the First Amendment, because you're penalizing somebody for their speech because it's the FCC. Now, if the company decided to take it off the air, that would have to be the public would have to rally to say don't do that because the company is a private actor. But when the FCC tells you better take it off, so that's the penalty they're imposing by taking it off. Yeah, but it's a problem because they're a federal agency. Yeah, saying that you can do that, and because you don't like the speech. I mean, that's the first thing. That's the one thing everybody knows about the Constitution is that we protect problematic speech. And we've had a lot of cases, by the way, that the Supreme Court has said we don't like. Where they've held the line on the speech because again, expressing that speech is what allows you to express dissent sometimes as well. Yeah.
Did you find it interesting that all of these people making those statements were all lawyers who knew better.
Who are yes. I don't find that interesting.
I'm very disheartened.
I'm disheartened. Yes, I find it disheartening. I would
They
use
had
that word.
con law.
I-
They knew
yes.
what the New York Times and the other case that had come down, and
Yes.
still they said it.
The
It
New York-
was amazing.
Right. That's a problem. So the other thing, I mean, you saw the law, if people saw the lawsuit against the Times, the court was like, when you have an actual complaint, when you then come back to the court. So you're absolutely right. It's like you're filing these papers as lawyers. You also took an oath as a lawyer, which I have too, because I was a litigator. There are ethics obligations. You can't file something unless you're filing in good faith. And so yes, it does bother me. And again, this is why I'm like, stop calling everything partisan. It's that's an ethical violation. It's not a partisan violation. You can't do that. The court that a court is telling you you have no cause of action here. Like, come back when you can actually identify a legal claim. That's I mean, one, that would be a huge embarrassment any other time. And the fact that, like, I don't know if it was or not, but the fact that it's also an ethics violation that you filed a claim without a good faith basis. Yeah.
If you did on a continuous basis, the State Bar Association would drag you in.
Exactly. So if you did it on, and if for anyone who can't hear the questions, if you did it on a continuous basis, that would be a violation of ethics rules. Yeah, absolutely, because you can't do that. And this is the problem. And it is very and I would use the word disheartening. It's disheartening to me that people are just not saying anything. You're standing and watching these, or you're agreeing to things like providing services from private law firms to the federal government. Why are people agreeing to these things? It's just, one, it's not sustainable, I think, over time, right? Because look at the number of people that are saying, what's happening here? We have all been taught this document, right, since we were in elementary school, and it's violating people's innate sense of, like, a balance of power. And so no matter what party you're from, everybody is concerned right now. And whether the people want to say it out loud or not say it out loud, there are more people concerned than there are people thinking this is great, and I think that's where we are right now. But then where are the people standing up for this document? That's what we have to think about, Sorry, was there a question back here?
Who are the people standing up for
Who are, exactly, I know.
Well,
Where
the
are
lower
the people?
courts.
If the founders say
Courts, some of
this
the courts
is
are.
the Constitution and this is not the Constitution, how did they see that you would make it, that you would rectify when people were not following the Constitution?
Oh, that's a great question. So yeah, that's a great question. So how come the founders couldn't anticipate some of these things? And what's really interesting about that is we have this breakdown of civic virtue. I mean, the founders, you can see, right? The founders, George Washington too, could have been a king. And he said, no, let somebody else take over. So the founders had this innate sense that, like, this power, politics is now an industry. And that's part of the problem, right? It's public service. It's a service. You're committed to the people, you're committed to the public, you're committed to the community. When things become an industry and it becomes about power and money gets involved, those ethical rules start getting eroded. And the problem is those rules are not written down. They were just presumed. And that's what we're realizing now is we have a lot of unwritten constitutional rules that are really the basis of the problem. So, for example, Supreme Court vacancies. We have a process for a regular vacancy, but we don't have a process written down when a president is in, like, the last 6 months of office, the last 1 year of office. Is it the next president that gets to a point? Is it the same president that gets to a point? And there was always sort of this understood rule. And then what happens if you're the same party that's saying, well, in one case it's one way, the other case is another way. Well, but there's no rule written to kind of challenge that. It was just sort of understood as a framework. And that's and we should be thinking about that, because all of these gaps now that we're having because we don't have these ethical rules, or we're not following that same sense of ethics, we need to think about, like, how do we fill that gap? And that could be either with an amendment or with some more federal legislation that, especially around electoral reform, that puts some parameters where we don't have those parameters in the Constitution. So yes, your question is an excellent one. The framers didn't envision this. I don't think the framers would have even ever envisioned, one, the scale of the country is different than what they were at the time, but something like campaign finance, unlimited funding being protected by the First Amendment, corporations having the same voice as people. I mean, just no, because yes, I mean, they are legal entities for sort of tax purposes. And they can be individuals, but to say that they have the same voice as an individual is going to now overpower those individual voices, because their voice gets amplified in so many ways. And the same thing with gerrymandering. If you allow districts to be unrepresentative, then you're not getting to that core foundational piece of popular sovereignty, which the framers were really big on. And so that's why, and we have to start thinking, how do we rebuild those ethical principles? How do we get back civic virtue? And so this is part of it. People now are like getting to a point where like, well, what are these rules and what should we be thinking about when it comes to civic engagement? So this is just another I talked about this already, but separation of powers issue, again, funding freezes, that has to do with executive overreach. And of course the biggest problem was the absolute immunity, right? And again, going back to what the framers envisioned or didn't envision, they specifically provided immunity, limited immunity for members of Congress, not for the executive, because the executive is the only one that risks being like a king. Right? Even though there's a direct election, it's different because you're directly elected by the people collectively, but you are sitting in one office overseeing everyone, whereas congressional representatives, right, are at least broken up by district. So that's a much smaller piece of the pie than being able to sit as the executive, which is why immunity, not giving absolute immunity, was so important to them. So again, these are foundational principles that if we look historically, right, they've been established. Yeah.
Court is full of originalists, am I right?
And exactly.
How did they make that make sense to them with the absolute immunity decision?
This is what I struggle with in class too, because I don't know. I mean, show me where you find it in Article 2. Show me where you see absolute immunity. In fact, it goes against the framers' intent. So I don't know where you could possibly find this in article. And this is what I try to tell my students also, because sometimes they'll say, okay, I like, or this justice is partisan, or that, or first, now they're referring to all the justices as Democratic and Republican, which is terrible because they're supposed to be isolated from partisan politics. But beyond that, they'll say, oh, well, that decision was just partisan because they don't agree with it. And what I try to tell them is if a justice is following their judicial philosophy, so an originalist is going to be different than a broad constructionist in outcome for anyway. But when I think you can call someone partisan when they break from that philosophy. So when an originalist comes up with a decision where you cannot find a textual justification for it, now all of a sudden you're like, wait, you're breaking with your philosophy. What is the justification for this? That starts to look partisan. So I'd like it to be where in Article 2 do we see the reference to, absolute immunity, not only limited, right? It basically is beyond what anybody had, which is why it was so problematic. Yeah. And I love this quote by Thomas Paine, in America, the law is king. The law is king. For in absolute governments, the king is law. So in free countries, the law ought to be king. And there ought to be no other. That's why they were so concerned about balancing power. And then this was just, I already talked about this, but that this isn't about one person, and it's not about this. It is about this moment because we're seeing kind of unprecedented attacks on the Constitution, but it's not just about this moment. It's about how we got here. And so we've already been sort of sliding away from some of these foundational principles like popular sovereignty, again, with things like gerrymandering and campaign finance. But again, the court does, and this is what's interesting about the court, is sometimes it does hold a line, usually on things like the First Amendment and due process. So the court's interesting. It's not like they don't always go one direction or the other. And in fact, what they're doing now, a lot of these decisions are temporary. So what's unprecedented is they usually don't use their temporary power this often, because it's not a real adjudication, right? It's not a full, but they're doing it so often now that that's also starting to look like a problem. But again, those things are all temporary because they'll come back and revisit those issues. And then, what can we do? And that's where we come in here, which is where you are. This is, I honestly believe, and this is what gives me hope, that people understand the difference between partisan debates and what is constitutionally right or wrong, or constitutional limits. And that's why you're seeing so many people coming out saying what's happening right now. And I think the way forward is to have that, to have that visible protest, to say, this is not okay, to have people come out, their rallies, to say, we're here for the Constitution, because that gets heard. And sometimes people will say, well, we're only, we're a small community. How can 30 of us make a difference? It makes a difference. It makes a difference, because those are things, I know it's people feel, but because it feels like the president can do whatever they want. They can't, though. This executive, any president, what you'll see happen is they'll redirect the conversation. It's like, well, something is happening, and now there's a lot of opposition, and so all of a sudden you won't hear about it anymore, right? And they'll kind of shift to, but that's actually a success, because that means that opposition was a constraint on that action. And the more we have that opposition, the more there'll be a constraint, which is what's basically required, right? But this document, we've never been in a situation where we had to kind of figure out. Yeah, I mean, this is why I do this. Is to be here with you and to answer any questions, because I've studied this document for so long, and I am an admirer of it. But I think our way forward is for us to be involved as the public, us, the community, to kind of be involved and to say, here's what the limits of government ought to be, and here's what this document means. So that's why I'm here to talk to you about this. I hope you learned something. I'm happy to take other questions too. Thank you very much.